On this episode of Law Weekly, we'll be having an in-depth analysis into the importance of electoral cases in Nigeria's law. We have the views of two senior advocates of Nigeria on this issue. Also on the program, we're in Anambra State, where a colloquium of lawyers discuss issues bordering on law practice management and the administration of justice in the courts, plus a recap of the trending stories from the courtrooms. Hello and welcome to the program. I'm Millicent Walker, standing in for Shola Shuele. For the past 9 months, the courts and tribunals have been busy with post-appeals from the presidential, governorship, Senate, and House of Representatives elections. We've seen some parties lose, while others jubilate from the various verdicts of the courts. Some senior advocates have been analyzing the importance of electoral cases and how it affects the development of Nigeria. We have their views up next. Thank you so much for talking to us today, sir. Electoral jurisprudence, especially as we've seen recent cases in Nigeria, what impact do you think it has had on Nigeria's legal system thus far?
Let me say that the impact at a point was positive, but at a point the impact has created some dwindling in the fortunes of democracy in Nigeria by the kind of principles of law that we started propounding in aid of what I call democratic dictatorship. Since we invented the principles of polling unit by polling unit, calling of witnesses, the principle that when you tender documents that are written in English language, you must demonstrate it. When we developed the principles of what they call dumping, when you get documents in from electoral bodies, you tender them, you are expected to speak to them in a manner that the courts or the tribunal will understand, and given the time frame within which to conclude proceedings, it becomes difficult for election losers to prove their case in the manner that their lordships have set the standard. And I think that we need to look at the standard of proof we have set in election petition, because all that it requires anybody to get declared as of today in Nigeria is to get the results, whether by hook or crook means. And by the time you get to the tribunal or the courts, then there are what I call jurisprudential roadblocks that have been mounted by our courts to defeat otherwise the laudable principles that the lawmaker had made to set up the tribunal.
There was a time you said we got it right, and then it appeared we didn't. To clarify.
Well, at the point when our judiciary and judicial officers have that boldness to call a spade a spade. You see, lawyers argued in court. Judicial officers decide cases. And it is what the judicial officer says is law, that is law. Lawyers only go to court to say, this is what I think it is. Then the judicial officers have the capacity to filter and look at the argument and come with a decision that not only meets the justice of the case, but that lays foundation for sustenance of democracy. When your decision has the potential and capacity to encourage political thuggery, political manipulation, political unit at all costs, and they are using the principles of law rubber stamp, because we have these things we call presumption of regularities. And I have always had my quarrel with us, that how do you presume regular what even the blind and the deaf know and hear that are not regular? How do you presume official act of INEC, for instance, regular, when in most cases it is such a notorious fact to everyone that officials of INEC, in most cases, look at state check, for instance, look at some of the elections in some of the states, for instance, elections in all the states conducted by each of the political parties in power are always won by that party in power. You ask yourself, what sort of democracy is that? Even when the government of that state had performed abysmally low, that even everyone knows that that government, that governor, that state is not performing well. Yet the state SEC returned where they chose to conduct a local government election. So I'm not comfortable that the judiciary is. I'm not comfortable with the performances of the judiciary when it comes to electoral jurisprudence.
How do you see the future of Nigeria's jurisprudence, and what changes or recommendations would you make?
I think I would recommend, one, either that we do away with court proceedings. Let the politicians go and dig it out with themselves. Since, as of today, the manner in which you become elected is no longer worrying us because there is a roadblock to probe into the manner you become a senator, House of Rep, governor, president. Because the burden is too heavier than a camel going through the eye of a needle. So I would therefore recommend that if we must use judiciary, that the burden of proof be shifted to the winners of the election, that he won the election in accordance with democratic process, and produce the evidence. Two, I recommend that we should de-emphasize the presumption of regularities of INEC, results declared by INEC, because that presumption of regularities, in a manner that we're interpreting it, had encouraged politicians to penetrate the staff of INEC. So, three, I would recommend that INEC be not a respondent to election petition. Four, I would recommend that we allow technological devices to be used for our elections rather than the manual collations of results. Once we have put in our electoral act that you must transmit results and scan, then the adding up, the calculation, everything be electronically done at the polling unit. Because creating room for manual collation of results had defeated the otherwise laudable provisions in the 2022 Electoral Act and the manual for election which INEC itself issued, which INEC is not being held to accountable, will be held to it. Meanwhile, in the previous regimes, INEC manual were held to be sacrosanct. Why are we deviating from that sacrosanctness of INEC manual? Fifth, I would recommend that we should get retired sound judicial officers of impeccable character to begin to man our electoral jurisprudence, electoral tribunals, and even Court of Appeal and the Supreme Court, and let the serving justice concentrate on other regular cases. Because I can tell you without being the fear of contradiction that election petition and election-related cases have retarded Nigerian access to justice in other areas. So we are over concentrating or looking for justice for politicians at the expense of justice for ordinary Nigerian people and the downtrodden. Mark you, Millicent, politicians believe that everything, including life, is obtainable by connection and by payment. After all, the principles of philosophy in Nigeria, that what money cannot do, more money can get it, was propounded by a politician, not Judex. And that is the level they can go. And they go through all manner of... So we need judges and lawyers who can resist the temptation. Permit me, in conclusion, the ecclesiastical example I want to give. If Joseph were to be a Nigerian, he would have gone to jail for attempted rape. But he fled away from the advances of Potiphar's wife. How many of us lawyers, and by extension Judex, can flee away from the temptations of dollars and pound sterlings and comfort of business class and first class to go outside of the soil of Nigeria that has everything but is lacking everything because of our leadership and our attitude? My darling sister, we are where we are because of whom we are. If we change our attitude and orientation, the Nigerian judiciary can hold the political class accountable. And they did it when they installed Amici. Heaven did not fall, because Ararume was an example of the circumventing of Supreme Court decision. The Supreme Court reasoned and said, look, after all, the ballot paper contained the name of political party, so let Amici become governor. And Amici was governor. Nothing happened. In the same way, we should also look at that philosophy and remove those who need to be removed from office. Otherwise, the manner in which we are going, politicians believe that iniquities pay. But in the court of equity, iniquity is not a license to have favor.
The 2022 Electoral Act made some impact in our electoral dispute. For instance, in the Electoral Act of 2010, repeal, under Section 29 of that Act, provides that any person who feels that a candidate has submitted a forged or false document can approach the court for redress. But in the 2022 Electoral Act, there is a paradigm shift from anyone and everyone to only the aspirant. So in the 2022 Electoral Act, for you to complain in court, for you to have what we call the local standing to complain in court against a person who has submitted a forged document or false information, you must be an aspirant. So it has limited those that can approach court for redress. And under Section 84, sub 12, 13, 14, you must be an aspirant to complain. This is one of the innovations that has helped in limiting number of cases, sometimes frivolous cases, that are filed in pre-election matters. And that decision, that provision was interpreted by the Supreme Court in the case of Oyetola against INEC. Oyetola against INEC is the locus classicus in the 2022 Electoral Act. And recently, the Court of Appeal sitting in Abuja, in the case of Reverend Yohana against Senator Cliff, interpreted that provision that when it is clear on the face of the document tendered by any party, certified by INEC, or the original, that there is non-compliance, you don't need to call oral evidence. So when you take some of these provisions into consideration, you will be safe to say that the 2022 Electoral Act has made some improvement in the resolution of our electoral disputes. I have serious grievance with the interpretation of issue of subpoena witnesses. Before now, authorities are to the effect that a subpoena witness does not need a witness statement to testify in court. And the reason is very simple. While you are filing your petition, you don't know who will be the subpoena witness. And in most cases, these subpoena witnesses are INEC witnesses. You are complaining against a decision or return made by INEC, and you are subpoenaing INEC to come and tender a document. It is impossible to get a witness statement from INEC or INEC staff to be filed along with your petition. It is impossible. Again, in some instances, you are subpoenaing official witnesses from government agencies whom you don't know, whom you don't even, you don't know the modus operandi of the organization. So how possible is it to get a witness statement from these people? And that is the reason behind the decisions like Lasun against Owoyemi, Patricia Ete, Kodla and Bashir, where the court then said, look, when it comes to subpoena witnesses, it does not require filing of witness statement. But the current trend and the current position of the law, stemming from the decision in Ararume and INEC, that for every subpoena witness in election petition, you must file his witness statement. And that has constituted a clog in prosecuting petition. If you have not prosecuted the petition before, you will not know how difficult it is to prosecute a petition. And for you to be expected to file a witness statement of an adverse party, honestly to me, it is an impossible task. So my advice to the legislators, because that provision and that interpretation is affecting all of us, it's affecting everybody, is to amend the Electoral Act to give room to supreme witnesses to testify without witness statement on oath. So that is a strong recommendation I will make for amendment of the Electoral Act in subsequent amendment.
Thank you for staying tuned. Coming up, we move to Awka, the Anambra State capital, where a colloquium for lawyers was held. The focal point of discuss was on law practice management and the quick dispensation of justice in courts. Let's bring you some parts of that event.
A gathering of legal minds is taking place in Onitsha, Anambra State, where men and women in the legal profession are convening to explore various aspects of legal practice. The focus includes topics such as succession planning, gender-based brain drain in litigation, and professional advertising, among others. During these deliberations, members of the bar highlighted that the event will not only elevate legal practice in Nigeria, but also pave the way for excellence and contribute to legal reforms. The prestigious C.J. Patterson Hall of the All Saints Cathedral in Onitsha, Anambra State, specifically the Presidential Wing, was the venue where distinguished leaders in the legal profession, senior advocates of Nigeria, judges and other stakeholders gathered for insightful discussions. This event, the third edition of the CO Honor Memorial Colloquium, seeks to encourage introspection among Nigerian lawyers regarding their roles in national development.
This event has become a symbol of intellectual exploration, knowledge exchange, and a celebration of our shared commitment to excellence in the delivery of legal services and necessary legal reforms that revitalizes the luster of the legal profession and strengthens the institutions that function in our sector so as to ensure the effective protection and enforcement of the rights of persons, families, communities, and businesses. We also aim to rekindle the consciousness of the litigation lawyer to the pivotal role he plays in national development and in the international human rights system. Our law offices are like theaters where we may birth new legal theories or perform corrective surgery on our jurisprudence. The law office is perhaps the most important as well as the most underrated space in the workings of the legal sector and indeed the state in general. There is an urgent need for us to revisit the structure and management of our offices. This need led us to the theme of this year's colloquium, practice management, the heartbeat of every legal career. We will distill progressive positions and transmit them in time to relevant stakeholders. So the activities around the colloquium don't end here. At the end, we take the position we have all adopted, agreed on, and in some cases disagreed on, and advance to the relevant authorities and say this is now what we want or this is what we do not want. We now complete that conversation and try to engineer legal reforms.
Speakers delivered thought-provoking speeches dissecting the conduct of legal practitioners as it relates to promoting services and attracting clients.
And when we talk about looking at these rules of advertising within the present realities, we are simply saying that the age is gone when you could put your name in a law list, in a directory, in this, print your card, put it on a letterhead, put it in a journal, put it in a signboard. It should not be big size. You don't even need to have a big size. But technology has come, the world has changed. The global market has changed. Then you could be here servicing clients in Hong Kong, in Singapore, in the US, by being in Onitsha. But how would they know you are here? So when you write articles, for example, if you specialize in trademarks, go and check the law firms in Lagos, Jackson, they do Garrick and others. They keep writing things about intellectual property. So when you want to Google on intellectual property in Nigeria, you find their names. So you may be the best lawyer on the channel. Nobody out there can find you on the internet. Bros, they won't come to you. Sometimes these foreign clients don't even know the lawyers. So they depend on what they can find out about them. Can a Google check discover you? Can we say anything about the things you do? Some of us have done fantastic cases that are trailblazing and locus classicals in our fields, but nobody's talking about it.
In the judiciary, part of our programs is encouraging continuous legal education. And workshops like this, colloquium, seminar, however you describe it, it impacts directly because it gives us a kind of enlightening. It exposes us to some of the things we hitherto did not even know. You had the learned senior advocate, Mazi Afamosiwe, talking about advertisement in the legal profession. He was able to, hitherto, some of us believe that advertisement is a no-go area. But he has been able to show subtle ways on which through which you can make some advertisements without breaching the law. So it impacts directly on the legal practice, legal profession, and directly on the judiciary, because it's it's a continuing legal education, which kind of enhances everybody, even when you do not realize. When you attend workshops like this, colloquium, seminar, you come out better off.
Numerous individuals depart from here with a revitalized perspective, emphasizing a heightened level of comprehension and a commitment to upholding professional ethics in the effective management of a thriving legal practice.
And before we leave, let's take a look at some of the stories that made the rounds this week in the courts.
We begin with the report that the Court of Appeal Abuja has upheld the judgment of the Kano State Tribunal, which sacked Governor Abba Yusuf. A three-member panel of the court, led by Justice Mo Adume, ruled that Mr. Abba Yusuf of the New Nigerian People's Party, NNPP, was not validly nominated for the Kano State governorship election. Governor Yusuf is challenging the tribunal judgment on 9 grounds, including that the tribunal erred for notifying his election on the basis of unsigned ballot paper, that the tribunal erred when it ruled that he was not properly nominated by his party, that the tribunal erred to have deducted all votes recorded in the unstamped ballot, 1 million naira cost against the Kano State governor. Staying with the Court of Appeal Abuja Division, which has declared as inconclusive the governorship election that held in Zamfara State on March 18. In a unanimous decision, the three-member panel led by Justice Oyebisi Folayemi nullified the return of Governor Dauda Lawal of the People's Democratic Party, PDP, as the winner of the governorship election. Justice Sibyl Nwaka, who read the lead judgment, ordered the Independent National Electoral Commission, INEC, to conduct a fresh election in 3 local government areas of the state where elections did not hold previously or where results from various polling units were not counted. The 3 local governments are Maradun, Brendan Magaji, and Bukuyum. The court held that it was wrong for INEC to rely on the information it obtained from its IREF portal to collate the final results of the governorship election. Meanwhile, the appeal court sitting in Lagos Island has affirmed the judgment of the election tribunal upholding the return of Babajide Sanwo-Olu and Kadri Hamzat as the governor and deputy governor of Lagos State. The appeal court panel led by Justice Yagata Nimpa in a unanimous decision dismissed the appeal filed by the People's Democratic Party and that of the Labour Party, as well as their candidates for lacking in merit. Meanwhile, Governor Sanwo-Olu in a statement hailed the judgment, just as the state deputy governor, Mr. Kadri Hamzat, who was present in court, said the verdict validates what transpired during the election. From the nation's capital, the federal government has arraigned the immediate past governor of the Central Bank of Nigeria, Mr. Godwin Emefiele, before a Federal Capital Territory High Court, Abuja, on a 6-count amended charges bordering on alleged procurement of vehicles to the tune of 1.6 billion naira. Mr. Emefiele pleaded not guilty to the charges when it was read to him. During the proceedings, Mr. Matthew Boka, Emefiele's counsel, applied for bail. This was vehemently opposed by Mr. Rotimi Oyedigbo, counsel to the federal government. In response, the presiding judge, Justice Hamza Mohazu, stated that a ruling on the bail application could not be delivered based on authorities referenced by both parties. He expressed the need to review the exhibit submitted by Emefiele in support of his bail application. He subsequently ordered that he be remanded at the Kuje Correctional Center till November 22nd, pending ruling on his bail application.
And that's the program for today. If you missed any part of it, check out our YouTube channel, and you can also give feedback on our social media platforms. Thanks for watching. I'm Millicent Walker.